My name is Garrett Kelly. I'm an Associate Director and Financial Controller here in O'Dwyer Property Management. I'm delighted you could join us here today for our monthly OMC Client Information Talk. Today's briefing is entitled The Mud Act 2 Years On. It's a very topical area which I'm sure you're all very interested in hearing more about. Our talk today has been given by Conal Toohey. Conal's the Managing Director of Kane Toohey Solicitors, and he has over 20 years experience in the legal profession. Conal specialises in employment law and commercial litigation and has a broad range of experience, including, more particularly for this talk, property related matters, and has acted on behalf of numerous management companies with regard to various building issues. So Conal's presentation will be approximately half an hour in length, and we'll have time afterwards for some questions. So I'll just hand you over now to Conal. Thanks.
Thank you. Good afternoon, ladies and gentlemen. Today's talk is on the Multi-Unit Development Act and the developments in the last number of years since it's been enacted. It's difficult, just in terms of preliminary observations, it's difficult to give a broad perspective on how the Act has been implemented, both in practical terms and, say, in terms of court applications, because whilst I will see a certain amount of work going past my desk, I don't necessarily know what's going on out there in the market generally. And in fact, I suspect that many of the people in this room, the property managers, may in fact have a broader perspective or experience, given the higher numbers of management companies that you would deal with. I will come back to that in terms of the litigation issues, which we'll canvass later on. The Act, in its explanatory memorandum, sets out what its objectives are. And as you can see, it's to address problems in relation to OMCs, both in new and existing developments, and to ensure fair and effective management. And I think those are the apt words to bear in mind when considering any issue. It's fair and effective. The reality is that before the coming into being of this Act, most well-run management companies were doing exactly what the Act now provides for. So it really ups the playing pitch for all those who in the past were not ensuring fair and effective management. In some cases. The talk I'm going to give today is going to go through those 5 objectives: compliance, resolution through litigation and mediation, overall compliance, and then just some minor issues in relation to noise abatement, etc. I won't spend too much time on that. I think we want to keep it a little bit more broad than that. Dealing with the transfer of common areas, the practical reasons for the non-transfer of common areas are twofold, and you see them there. Lack of interest, lack of funds. The most difficult situation is one where the developer is just not trading. They don't exist, they don't care, they're not around. That's a difficult situation to try to resolve, because at least if a company is in liquidation, it means a liquidator is in, and you can therefore prevail upon them to ensure that whatever has to be done is done. Most liquidators will want to clean up the liquidation as quick as they can. They realise they have to transfer out the common areas, and therefore they're to a point a willing participant in the process, which is in, I suppose, the opposite for those companies that have ceased trading but in relation to which there's no liquidator appointed. For those companies, which is probably more the case these days, where receivers have been appointed, generally interaction with the receiver is dependent upon whether the receiver perceives what in their best interests or that of the charge holder is. So if they perceive that it's in their best interest to engage, they will engage, and if they perceive that it's not, then they will not. It's important to remember the receiver does not occupy the same position as a liquidator, and so you can't prevail upon them to transfer the common areas in the same way that you might with a liquidator. The receiver takes their powers from the underlying charge, and it may be that the charge is over a number of the units in the development as opposed to the common areas. It will require you, in the event of a dispute or issues, to look at the charge document to see the extent of the receiver's powers. the general observation holds, which is if they will work with you if it's in their interest to work with you. It's important to bear in mind as well, especially in the area of service charges, which falls outside the scope of today's talk, that generally receivers will not pay service charges pre their appointment, but can generally be prevailed upon to pay the service charges post their appointment. From a practical perspective, in the event of a sale, a management company will have some leverage whereby they can refuse perhaps to assist in requisitions until they get an undertaking from the receiver solicitors to pay all service charges pre and post receivership out of the proceeds of sale. And that happens in many cases. In one or two, it doesn't. And in one or two, the receiver digs in their heels and do not pay. And that falls to the members who do pay. It's a void in your service charges and may well be irrecoverable. The transfer of the common areas is, how would I put this? It's honoured more in the breach than the observance. Many management companies have still not had the common areas transferred to them, even though there is a statutory obligation to do so within 6 months from the coming into force of the Act, which meant that it had to be done by the 30th of September 2011, and the overwhelming majority of management companies are in default in that respect. There is no penalty provided for in this Act such that someone who fails is penalised. The most you can do is bring an application to court to seek a court order directing that they do so, and if they remain in breach of a court order, then that's a civil wrong and actionable at court. A court order, courts guard their jurisdiction and their powers jealously, so if they make an order, they expect it to be complied with, and if it's not complied with, there are very serious sanctions up to and including imprisonment. So whilst you might advise a developer management company that although you have a statutory obligation to transfer, there's no sanction, if a court order is made, then they need to sit up and take notice because of the implications of not complying with it. Sections 3 and 4, without getting into too much detail, in a management company where there has been no units sold or where less than 80% of the units have been sold, the developer's obligation to transfer the common areas is caveated in the sense that they can hold on to the beneficial interest in the common areas. So property is comprised of both a legal interest and a beneficial interest. They must transfer the legal, but they hold on to the beneficial, and this is to assist them in completing the development. For those units for those developments where more than 80% of the units have been sold, the developer must transfer both the legal and the beneficial interest. When the development is complete, all the units have been sold, then at that point the developer has to enter into what's called a statutory declaration to confirm that the beneficial interest is now merged. From a conveyancing perspective, and I hold up my hand, I am not a conveyancer, I don't practice the black art, but as I understand it, it makes it much easier and smoother where the two interests are merged. On a practical point, the absence of a transfer of the common areas hasn't held up sales. I know when this Act came into being, there was a concern that failure to comply would effectively preclude the sale of second-hand apartments. Practically speaking, that hasn't arisen. The Law Society has given directions to its members that the mere fact of the transfer not having taken place is not a reason not to close. They'll raise requisitions, and depending on circumstances, the management company may be able to allay concerns and indicate that the transfer is in hand or steps are being taken, and that's usually sufficient. Just a small point in relation to the merger of the interests. It's subject to a charge holder's entitlement, so I'll just move on here. So if the developer bought, and they did so with finance, then the finance that they got is now charged as security over the property. And that security may extend to the common areas. The charge holder at the time when the development is complete and the units have been sold cannot unreasonably withhold their consent to the developer transferring the interest. Although, having said that, if the charge holder refuses because the developer has refused to give them security over, say, a unit remaining in the developer's ownership, then that would be a good ground to refuse. As far as I'm aware, it hasn't yet come before the court, so there's been no testing of it. From a practical perspective, I can't see a charge holder standing on their rights and insisting that they will not release security over common areas. Thinking about it outside the box, I could imagine a situation where, for example, let's say a development has been completed, but part of the planning entitled the developer to, say, build penthouses at the top of the development, which I've come across in one or two developments. Then you could see where a charge holder may be reluctant to release their security over the common areas where they see further development occurring, and therefore enhancing their security, or at least giving them some leverage to do so. Sorry, we've just covered that point. That's the particular section dealing with the charge holder withholding their consent. Dispute resolution, it's an important function of this legislation, and it's done in one of two ways. It's litigation and or mediation. The Act sets out a very broad range of reliefs or orders that the court can make, and it allows a very broad range of people who can come before the court. The definition of those who can, or who you might refer to as stakeholders, is quite broad. Not unreasonably, it includes the management company itself, the developer, a unit owner, personal representatives of unit owners, or indeed any person who the court is satisfied has established an interest. So it's a catch-all. So anybody who can stand up in court and say, and explain why they are there and what they're interested in, will invariably be allowed to bring the application. Going back to the reliefs, the orders that can be made, is very broad. There is a section 24.5, lists an example of the types of orders that can be made: varying covenants and leases, restructuring the management company scheme of development, restructuring the documentation, allowing the creation of separate management companies within the same development if that is appropriate. So it's very broad, and it's not exhaustive. So pretty much the court can do what it deems fit and what's fair and reasonable in all the circumstances. The jurisdiction is given to the circuit court, and that's important from a costs perspective. Previously, a lot of litigation had to unfold in the High Court, and the High Court is an expensive place to litigate. The costs you incur there are a multitude of what you would incur in the circuit court. And that's obviously to be welcomed. It lessens the cost exposure. The second bullet point there deals with orders directing the developer to complete in accordance with the contract, planning or building controls. And that's an apt, I suppose, subject matter given recent developments, Priory Hall being foremost to the mind. When it deals there in terms of a contract, it's a bit of a euphemism because, as you are probably aware, there is invariably no contract between the developer and the management company for the construction of the common areas. It just doesn't exist. There's an agreement to transfer the common areas, and then there's the subsequent transfer, but there's no contract. So there's no contractual rights ascribed to both parties, such as you would normally expect to see between two people who have agreed to build a development. So, to be quite honest, it's going to be rare, I would have thought, where the court will be considering that issue in the context of a contract. Having said that, it does refer to planning permission and building controls. It's been my advice in the past to various management companies that if they have come across a host of defects, what you invariably find is a mixed bag of what is really snagging or maintenance issues with which the developer should not be concerned, and more substantive defects. And in my view, of those substantive defects, which are the ones you should concentrate on, If you can show that those defects fall within planning or building control, then it seems to me you would have a good case to at least get it before the circuit court rather than going off to the High Court, because it gives you a slightly faster track process and at less cost. Having said that, so I'll come on to the mediation shortly, but my last comment on the litigation, from a technical perspective, it was open to the powers that be to ensure that access to the court could have been by way of what they call in the trade an originating notice of motion. Basically what that means is you get into court very quickly. So you go in on the back of an application which sets out the types of relief that you want. You ground it or you base it on an affidavit, which is a sworn statement setting out what the issues are, what problems have arisen, and what you want from the court. And it makes for a very quick process to get in and get out. Unfortunately, for whatever reason, the powers that be decided not to use that fast-track procedure, and instead they've gone down what I will call the plenary route, which means you have to commence your claim by way of an originating writ or summons. That's served, an appearance comes in, a defence is delivered, replies and particulars and information is sought. So you're into a much longer process with an exchange of court documents, discovery, and eventually the matter set down for trial, which elongates the process and adds to cost. That doesn't mean to say you can't get into court urgently on an application if the circumstances merit it. You can, known as an injunction, but by and large you're restrained by the slightly longer process that they've inserted. Perhaps the quid pro quo for deciding to go down that route is mediation, known as dispute resolution in the Act. And this is to be welcomed. Mediation is an alternative dispute mechanism, which means it's an option which can be pursued to resolve the problems outside the court process. Invariably, that means less cost and a quicker resolution. It is very important to remember that mediation is not arbitration. The two are as different as litigation to mediation. Arbitration is the same as litigation. It's just that you go to an arbitrator who you pay rather than a judge who you shouldn't. So with mediation, you retain an independent third-party mediator who is independent of the parties, need not necessarily have an expertise in the area of management companies, but who is a skilled and professional mediator with experience of assisting parties in resolving their issues. They don't impose a solution on you, unlike an arbitrator or a judge. What they do is they bring the parties together such that the gap is bridged, and if the parties are amenable to entering into a settlement agreement. If the parties are willing to do that, then they sign up to the settlement agreement, recording whatever agreement they have reached. That is now a binding contract, and if either party defaults, then the innocent party can sue on it as you would sue on any contract. It is an extremely effective mechanism, provided parties come to it in good faith, and I'll come on to that a little bit later. There are a number of lists of mediators maintained by the Law Society who are approved mediators that can be availed of in the event of a dispute. Invariably, they're usually lawyers, but not always, and they don't have to be lawyers either. The court has the power to direct parties to go to mediation. For that reason, it's very important, if you are at the start of your row, for want of a better word, that when you're sending out your demand, or whatever solicitor you've instructed to do so, setting out what the whole host of issues are and what the defaults are and what you want the other person to do, very important to work in a mediation clause. Not alone because it's good practice, but also because it will protect you on costs. Because if you tear off into court, not having offered mediation, and the other side then come in and say, well, Judge, if they'd offered us mediation, we would have accepted it. We've therefore incurred costs coming into court needlessly. Could you please penalise them as to costs and let us go to mediate? So important, just a small point, make sure that your solicitor includes that mediation provision. Section 28(3) of the Act, which again on the mediation, imposes certain cost sanctions, so that if the court concludes that a party's conduct is substantially the reason for why the mediation failed, then that person could be penalised on cost by having an adverse costs order made against them. And what they're trying to capture there is, in many cases, let's say a court directs people to mediate. Of course, it depends on good faith. So one party could say, well, yes, I will mediate. And then they go to the mediation and they just sit there and they look at the mediator and they do not participate. They are obviously only there because they've been told to be there. They're doing it out of a sense of form rather than substance, and effectively they have no interest in resolving the matter. And it's designed, this particular section is designed to remedy that, or at least put a barrier against it. Which brings on to an observation that I have just from my own experience of mediations, not only in management companies but otherwise. The mediation process is a without prejudice process. Without prejudice means that it's without prejudice to the parties' rights. So it allows parties to freely engage with the other side without fear that an admission of a fact or a statement will then be used against them in a court process. And the courts favour without prejudice processes because it frees up parties to engage on a relatively free basis without fear of tripping over themselves. For that reason, mediators guard the process jealously. I know many mediators who will immediately destroy their notes after a mediation, and invariably in their agreement to mediate they will have a provision to the effect that they will not be called as a witness in the event that the parties don't solve their differences and proceed to litigation. These sections interpose the court into the process, and they direct that the mediator furnish a report and give an opinion as to whether the failure to settle was as a result of one or other party's intransigence. I can see difficulties arising with that, and many mediators may bridle at that because they will see that as an unwarranted interference in the without prejudice process. Again, I'm not aware that that's come before the court, but it is there and it is part of the statute. Moving on to the fourth section, general compliance. Compliance is a statutory requirement, it's a statutory duty, and avoid it at your peril, but I go back to my earlier comments when I said that there's no sanction, save for going to court and getting a court order. In my experience, most OMCs and their property managers are sincere in their efforts to do so. A very small number either can't be bothered or know what's required but just simply decide not to comply. That's very rare. Just a couple of general observations in relation to my experience of some issues over the years. Voting rights, typically before this Act, when you got involved on behalf of a management company, the first thing you do, especially with a dispute with the developer, you go to the Articles of Association. And invariably you find a clause buried in there which gives to the developer or their nominee subscribers 1,000 shares each. So they can completely outvote the members at a general meeting. Or alternatively, they don't even give members a vote at a general meeting until the transfer of the common areas has taken place. And so what this means is that not only does the developer control the management company at board level through their nominees, they also control the management company at general meeting level through their hold on votes. So that even if the members wanted to vote through a resolution, perhaps to litigate or do something of concern to them, they would be voted down. This Act changes that. It's now one vote of equal value in respect of each unit, and no other person is entitled to voting rights. And Section 15 makes similar provisions for OMCs which are not mixed use. That's important in the following way. In a non-mixed use development where it's purely residential, a developer may still have rights and voting rights, but in order to exercise the vote, the developer must first go to court and get an order from the judge entitling them to use their weighted votes, and they have to show that they have an essential economic interest or that it's fair and reasonable in all the circumstances. For mixed use developments, there's no such barrier. The developer, if they have weighted votes, can use those votes without having to get prior court approval, in which case it's open to somebody of an interest on the other side, a member or the OMC itself, to go to court to seek an order under Section 24, depriving the developer of that right for whatever reason they say. It's disproportionate, it's unfair, it's inequitable, whatever the facts might suggest. Restoration to the register, I won't spend much time on that. In short, it's extended the time within which you can put a company back on the company register if it's been struck off, and that extended period is now 6 years. Previously, I think it was 1. By the way, that's only available to management companies where the common areas have transferred. Retention of monies, I really don't know why I put this in, because it was never implemented. There was a suggestion by the Law Reform Commission that 5% of the purchase monies would be paid, if you like, to be held in trust pending certification of completion. It wasn't implemented. The sinking fund, I suspect this probably causes more headaches than many other provisions in the Act for property managers. It sets out a scheme whereby a fund known as the sinking fund, which you're all familiar with, should be established, and it makes perfect sense that it should be so. So you build up a fund to deal with any defects. In my experience, however, because of the relatively strict language around the categories of works that you can do and fund from that sinking fund, you're usually doing a little bit of violence to language in order to bring in whatever works you have in mind within Section 19. Because Section 18, dealing with service charges generally, is for ongoing maintenance and the provision of services, and therefore isn't usually available to you to use for what might be substantive issues. This is particularly so in the context of a provision in the Act which states that you cannot use members' funds for remedying builders' defects unless 75% of the unit owners agree to it in writing. Impossible, absolutely impossible for you to get 75% of all unit owners to agree to that in writing. It's just not going to happen from a practical perspective. Which means that an OMC could be left with a situation where the developer's gone, there are defects in the building, and yet there's this prohibition on using funds, and that's why you go through contortions to try and bring it within Section 19 to use those funds. And it's an important issue, because if you get it wrong and you purport to use a sinking fund, or you issue a service charge demand halfway during your year to levy, which is a word I don't like being used in the context of service charges, but which you use to gather in funds to take care of a problem, one of two things could happen. Either A, someone's not going to pay, and when you go to sue them, they argue that this is ultra vires Section 19, it's outside the remit of Section 19, and therefore I shouldn't have to pay. Or alternatively, somebody will go to court and say, you can't use the sinking funds to do this. So it can get a little bit tricky where a developer is gone, defects have to be dealt with, and the language of the Act is less than clear. We've dealt with Section 18, and we've dealt with that second bullet point just there. I'm not keeping up to date with myself on the slides. I'll just go back one slide for the moment. Just a couple of comments in relation to service charges. Prior to the enactment of the Act, in order for you to sue for your service charges, you were doing so based on the lease. The lease was your contract. It provides a covenant on the part of the management company to provide services, the quid pro quo being the covenant by the unit owner to pay for the services on whatever the apportionment is set out in the lease. Which meant that when you went to sue, you must produce the lease in court and you must prove it. A document doesn't prove itself, so you must put a director of the management company into the witness box to say, is that the lease of X to Y? Yes, it is. Is that the covenant whereby they must pay service charges? Yes, it is. You've now proved your document. It's old-fashioned, but that's the way it's done. And you had huge difficulties if you couldn't produce the lease and if you were put on strict proof. So if the other side said, well, prove everything, I'm not going to make any admissions, prove everything, you had a difficulty. The fallback situation, that was one difficulty. The other difficulty was developer voids, as they're euphemistically called, which are service charges due by developers on unsold units which they may not pay. Major headache, because it creates huge gaps in accounts and therefore huge problems for funding. I have never come across a situation where a developer has held on to the unit by entering into a lease to himself or herself in respect of it. So they hold that lease by virtue of the title that they hold for the overall development, out of which has been carved individual leases for units, and therefore that which remains in their possession by virtue of their overall title. So they don't have a specific lease, which means, of course, they never gave a covenant to pay service charges, which means, of course, you can't sue them on something that doesn't exist. How then to sue? It's a big, or at least it was a big problem. The only way around it, in my experience, was to use a rather long-winded process called a claim in quantum meruit, which is it's a quasi-tortious claim. So what you're doing is you're saying, well, I don't have a contract, I don't have a covenant, but I can sue for the value of service, quantum meruit, the value of the services. So the management company would say, well, the developer has, by virtue of the provision by the management company of services, derived a benefit by virtue of there being insurance, lighting, lifts working, and all the other services that conspire to make a good development. You, the developer, have profited from that or benefited from it, whether because you rent the units, you hold the units, you derive a benefit. The problem with such a claim is it's a very long-winded claim because you must technically prove every single invoice behind the service charges provided, which means literally coming into court with lever arches full of invoices to prove, yes, that's the invoice for the maintenance, that's the invoice for the lighting, that's the invoice for this, that and the other. It's a long-winded claim. Thankfully, the Act now states that service charges shall be construed as an ordinary contract debt. It makes it much simpler to sue for. However, given the requirements of Section 18 for management service charges, and how they are to be approved by members in general meeting, you must prove that process if you're put on strict proof, which means that if a management company has not gone through the Section 18 process correctly, and the defendant unit owner twigs that, or their lawyers twig it, then they'll use that as their defence to say, there is in fact no lawful basis to make this demand of me, because the underlying requirements of Section 18 have not been met. Go away, and you're back to square one. So in some cases you could see that defence being used, which will require the management company through its property manager or agents having their paperwork in order, being able to point to the minutes of the AGM which approved the budget and the amount and the apportionment process, and move from there. Just a few comments on jurisdiction. The jurisdiction of the courts is to be changed shortly, we hear. So for claims up to about 6,000 you go in the district court. For anything between 6 and about 38,000 you're in the circuit court. Anything above 38 you're in the high court, with a huge variation in costs associated with which court. High court is mad, circuit court is less mad, and the district court is reasonably mad. They are being changed so that the jurisdiction of the circuit court is going to go to 15,000 and the circuit court to 75 and 70 in particular cases, which is good because it means you could now bring a claim in the circuit court which before you had to go in the high court, with a consequent saving in costs, and similarly so for the district court. One final point in relation to service charges. There's a carve out in the personal insolvency legislation, whereby service charges fall out of the debt. They're defined in that legislation as excluded debt, which means that the person seeking an insolvency arrangement cannot capture within that arrangement service charges. And there's a very good rationale for that, because it has such a disproportionate effect on their neighbours if they are able to get off their obligations when the person beside them in the same development down the corridor for them is paying up. It would, as you can imagine, it would create a lot of disharmony and ill feeling. However, be aware, especially as property managers, insolvency practitioners, or PIPs in this context, who may be acting for people seeking the insolvency arrangement, they can write to you, and they'll do it in the most innocuous of terms, designed to, not to hoodwink you, but perhaps to lull you, and they'll put in a sentence to suggest that they would like service charges to be included as debt for the purpose of the arrangement. And they will hope that you don't respond, because a failure to respond will be deemed consent to the service charge forming part of the debt captured by the arrangement. So at your peril, don't respond, because it means the service charge becomes part of the insolvency arrangement. You must respond negatively to say, no, the management company, and make sure you're saying it on behalf of the management company and not yourself as the property manager, the management company does not consent to the inclusion of service charges in your arrangement. Just be wary of that. Otherwise you could see how advantage might be taken, and suddenly you realise that a chunk of your service charges is now part of an insolvency arrangement, and you might get whatever, 5 cents in the euro or whatever you might get. House rules, I won't spend long on these. To be honest, I think it's meaningless. They've said that you can enact house rules, big deal. There's no provision for enforcement. The house rules must be in conformity with the lease. Remember, the lease is the contract. You can't go outside the contract. So if you start introducing house rules, which, for example, let's say somebody under the lease has been given the use of a car parking space. There's no prohibition in that lease as to that owner's right to sublet the space. But the members decide, or the board decides, it's a good idea to ensure, for security reasons and very valid reasons, no one should be subletting spaces to strangers, because we don't like people coming in who have no proprietary interest in the development, and they have a fob switch to the car park, and there's all sorts of security issues. Does that allow them into the common areas, etc.? So there may be very good valid reasons for not permitting the letting of or the subletting of a space. But if it's not in the contract, if it's not in the lease, you can't dream up that prohibition, stick it into house rules, approve them at general meeting, and then expect everybody to be bound by them. Although the Act says that everyone is going to be bound by them, in my view, I don't see a statutory entitlement like that can effectively override a property right. So that'll make for a very interesting dispute, I would have thought, between, on the one hand, somebody who claims that under their lease they have a property right to this space and they cannot be restrained in how it's used, versus house rules which are purporting to do so. There's a short piece there on the EPA. This is a very effective resolution. What probably gives management companies, and in particular property managers, a headache is noise and complaints by owners in relation to noise. And on one level it's simple, and on the other hand it is very complex, because when you're communicating to the party against whom the noise allegation is being made, you're very conscious of data protection issues, you're very conscious of defamation issues, and you're drafting your letters tightly to ensure that you do not give a hostage to fortune. So it's a very difficult balancing process. In my view, whilst management companies should take up cudgels to a point and bring to the attention of the person against whom it is alleged noise has been generated, bring it to their attention that a complaint has been made and ask them to address the issue. If it is not addressed and it continues to smoulder and jump up and down, whilst the management company can take it to a point, ultimately I believe it's a matter for the complainant to take issue. And so if the complainant is jumping up and down about this noise issue, and for example no one else is, very politely and courteously refer the complainant to the EPA. It's the Environmental Protection Act 1992. It allows for a very inexpensive process whereby you can get into the district court and get a noise abatement order. So if you're the person complaining, off you go. Don't expect the management company to do the running for you. There's the process. You're entitled to bring your claim, produce your evidence, and get your order. That should be the process I think you follow, and that's all I have to say in relation to noise. We've dealt with the House rules there. As far as I'm aware, although the Minister can make regulations re House rules, I'm not aware that he has. In conclusion, the purpose of the Act was to solve the problems. Going back to my comment about fair and effective management, that is the hallmark of it, that is what the objective is. The Mud Act is not the cure for all ills. It's a useful framework. It's to be welcomed in that context. There are many shortfallings in it. I think some of the shortfallings in it are justified and others are not. For example, many people have made the point that it doesn't deal with recalcitrant developers who have failed in their obligations. Well, yes, that's true, it doesn't, but that's not what this Act is about. You would have to amend a whole host of other legislation in order to deal with that principle. For example, building regulations exemplified by the Priory Hall debacle, and it would be very difficult for an Act such as this to try and cater for a situation like that. My first observation still holds, which is that all well-run management companies were, by and large, doing what this Act provides. So for those management companies, there's been no significant change in the regime. There's been no significant increase in owners' burdens now to meet in terms of management, because you were doing it anyway. The only other comment I would make is that it's silent in relation to directors of management companies, and I think it missed an opportunity to deal with that. I think management companies are only as good as the boards of management, and that is dependent upon owners giving voluntarily of their time to become a director. By becoming a director of a management company, you assume statutory and common law obligations and duties. Some people will be au fait just through their own experience and background with how companies operate and the need for a process, a corporate governance process in terms of procedures, the requirement for board meetings, the requirement for board minutes, the requirement for agendas to be circulated in advance, for invitations to be given to all directors to attend. And you will be surprised, or perhaps not, given that you're on the ground dealing with this. In many situations, there might be a split in the board, and some decide it's a great idea not to invite Johnny to the meeting because he just delays it inordinately and is difficult to deal with. You can't govern like that. You must follow the rules, or it will come back to bite. And I think as property managers, you would do well to, as I'm sure you probably already do, to give some sort of a briefing note or an explanation in terms of good corporate governance to all existing and new directors on management companies. It would enhance their experience, their understanding of what's expected of them, and therefore make your life easier in the round. My concluding comment, I think, is that it is a framework. It's a starting point. It's not the end line. There will undoubtedly be amending legislation. One comment I didn't make, which I said I would, which was in relation to just a general awareness of what's going on. Whilst I've brought certain applications under Section 24 to the Circuit Court, the Circuit Court does not publish its judgments, unlike the High Court. So, and in fact, in many cases in the Circuit Court, a judge will give what's called an ex tempore decision, which means verbal. There's no note of it except if you're the solicitor in court and you happen to scribble down the note of what the judge is saying in terms of the order or the judgment that they are delivering. Which means that there's a real information deficit. So in preparing this talk, I got our law clerk to go down to the Circuit Court office to see, well, have any judgments been issued? How many writs have been issued under the Section 24? Couldn't get the information, because unless you're the solicitor on record, you're not entitled to look at the file. So there's an information gap, certainly at my level. And again, I put it back to the property managers, because the breadth and expanse of your management companies is always going to be much broader than mine, because I'm just dealing with the problems and you'll have many where there are no problems. But you might have a greater perspective or awareness of what's going on in terms of claims made. And you could actually feed in, this is something I made at an earlier conference, maybe through your representative association, you could begin some information sharing process whereby everyone's information levels were brought up by reference to what is going on in the court. Otherwise, we're just relying on ad hoc commentary by people who happen to be in court on the day or who are involved in a particular case. So thank you very much for your attention. It's a pleasure to give the talk. If you have any questions, I'll happily deal with them. Yes.
Michael, I have a question just as it's come through our web stream. The question being asked is, if a developer has failed to comply with regulations, including fire regulations, but is in NAMA, can the OMC use the provisions of the Act, including seeking mediation?
Qualified, yes. Dealing first with the issue of NAMA. NAMA is neither here nor there in that context. NAMA is simply the charge holder. It's just that they've bought the debt from whoever the original provider of finance was. So by virtue of the fact that they're in NAMA, doesn't preclude you from dealing with the developer. From a practical perspective, you would have to make the assumption that if they're in NAMA, they don't have any money, in which case suing them to either do something or to pay you money will be a waste of time and your own costs. What's the point in getting a judgment against somebody or getting an order directing that they do works if they don't have the finance or the money necessary to do so? It means you'll have spent time and money yourself getting to a judgment which can't ultimately be practically enforced. Because whatever I said about civil orders before, if you get a monetary judgment against somebody, if they can't pay, they can't pay. And no court will put anyone in jail or wind up, well, they may wind up the developer, but they're not going to put anyone in jail because of an inability to pay. They may well do so if they take the view that the person is refusing to pay, which is an entirely different story. In terms of fire regulations, I am not an expert in fire regulations, but it seems to me if the breach of fire regulations can be brought within either planning, which I doubt, or building control regulations, the Building Control Act, then that, to my mind, might open up the possibility of going into the Circuit Court on the basis that errant fire regulations are caught by the building control. But you'd need expert advice from a fire consultant or engineer or architect to show that that is so, i.e. that the fire regulations are covered by the Building Control Act.
Thank you.
You're welcome.
Are you aware of any OMCs who have successfully used MUD legislation in relation to the transfer of common areas?
Well, yes, I took one case. It didn't result in a decision because actually it went to mediation. Sorry, in fact, in that case, actually, no, the transfer of the common areas had already taken place. It was really an issue about voting rights. So I'm not personally aware of any decision having been granted by the court directing the transfer of the common areas. So the short answer is no, I'm not aware. No.
Donald, just in relation to receivers of where an owner gets into trouble and receivers are appointed over the units that they own, has the receiver in that situation got an obligation to pay service charge? Or I understand what you say, not for the past, going forward.
I haven't yet sued a receiver for the service charges which accrue during their appointment. I've threatened it and I've issued proceedings, but they haven't gone any further. And you can see the defences that a receiver would raise to any claim, which is that, well, they're simply in as the receiver over the property, and therefore they don't assume the debts or liabilities associated with the charge, with the borrower referable to that unit. It's like, for example, well, maybe this is a poor analogy, but I'll make it anyway. Let's say the receiver goes in over a company's assets and decides to trade out of a unit that is rented to that company. Well, in that case, the receiver, and all of them will well acknowledge, they have to pay rent while they're there. And so by analogy, you would argue that they should also pay service charges because they're benefiting from the service charges. So I think you'd have a good case against a receiver, and I think they know that, and the overwhelming majority do eventually pay up. Now, it takes a bit of pushing and shoving. Very few write the cheque immediately, because with all receivers today, it's all about, use that silly phrase, sweating the asset. So the bank appoints the receiver. The bank is already in the red on this account. They do not want to fund more money into the deep well. So they say to the receiver, well, here it is, off you go. Rent it, sell it, do what you like, but I'm not paying you till I get something back. So, of course, it gives the receivers a vested interest to do something with the asset quickly, whether it's renting or selling. And it's only really where they have an income stream, whether through rent or an anticipated sale, that they will stand up. Very few will actually subvent by paying service charges, certainly not out of their own office account. So, although in some cases they have gone back to the bank in a particular situation and the bank has actually put the money up. I certainly come across that situation.
Okay, and would it be a recommendation in those situations, say, to keep past amounts due to amounts since the receiver separate?
I certainly have done that in the past. I've said to the agents where the receiver comes in, I said, do an apportionment exercise pre and post. Because the receivers know well whatever responsibilities they have post, really known pre. And so, whilst for the purposes of getting in at least their portion, I say do the apportionment. But if we get a hint of a sale, they'll be getting the entire account. And once they've agreed or they undertake to pay out of the proceeds, then they get cooperation in terms of requisitions on title, etc. So there's a bit of leveraging going on invariably. Yeah.
Thanks.
You're welcome.
Thank you very much, Alan. That was an excellent talk. You touched at the end on what I think is probably a glaring omission in the Act, is the sort of required need for a continued supply of directors, generally made up of owners in the apartment blocks. And there will be eventually a shortage of goodwill or civic-minded individuals that are prepared to put themselves forward for that role without any compensation. So what happens in the event that a developer generally would be the director, I suppose, in the company when it's initially set up?
Yeah.
That's subject to a 3-year time limit, I think, isn't it? That no director shall hold that office for a period of 3 years.
Sure.
In the event that you can't find any other director or nobody comes forward from the apartment block, what happens in those circumstances?
Well, in theory, if there's no directors, then you're in breach of the Companies Acts and open to sanction by certainly the Companies Office can prosecute you in the district court and impose a fine. Can prosecute the management company. The management company, because it has allowed a situation to unfold where it has no officers. Remember, the management company, it's a separate legal entity. It's managed by a board, but it's owned, if you like, by its members. And so there's a number of implications arising from that. The first is what I've just outlined. The second is, for example, if there's no board, how can it function? In theory, legal theory would mean that the functions of the board devolve back to the members at general meeting, which of course is a mad way to run a management company, convening a general meeting of the members every time you need to take a decision. But that's the legal theory, whereby no board, ergo back to the members at general meeting. And so if the situation did present itself from a practical observation, you would need to write to all members to alert them to this possibility and to the downside or disadvantage that this poses for them, their homes and or their investments, and make them see, to the extent that you can, that it is in their vested interest for someone to step forward and take up the mantle.
Just, sorry, Colin. Just following up on that, is it possible then, in a situation where directors can't be found or are reluctant, to actually agree a charge at general meeting where directors would get some remuneration for acting on behalf of the management company?
So are you asking, Hurley, is that permissible?
Yes,
or
is that permissible?
You need to. The starting point is back to the Articles of Association. Some Articles of Association that I've seen do preclude emoluments or payments to a director, in which case there's a prohibition on it and you can't do it. And if you did, it's ultra vires the company and therefore void. Absent a prohibition in the Articles of Association, on the strength of it, there's no legal reason why some sort of compensation package could not be agreed for directors to compensate them for their time and their efforts. From a political, with a small p perspective, you can just imagine the fun at a general meeting where that's been discussed, because you'll either have a stampede to the board table by members who wish to be members, or you'll create bad blood, and people will thinking, well, why am I paying Mary, whatever the going rate for a non-executive directorship in companies in this state is 10 to 12,000 a year, which obliges you to pitch up at a board meeting once a month and to have read the board papers in advance. I'm not suggesting that that is in any way an appropriate charge, or indeed am I suggesting that it is appropriate to pay directors. I express no view on that, but you can see the issues that it would undoubtedly give rise to in terms of communal living arrangements and people getting on one with the other. Some will think it's a great idea because it obviously prompts people, or at least compensates people for their time and their effort. Others will see it as a very bad idea. And effectively it would come down, I suspect, to a vote and let the members decide.
Just one question. If you were having a nuisance neighbours, so people making noise,
yes,
you go to the district court, have they any deed?
Oh, they do, yeah. I mean, if the district court makes a noise abatement order, it's a court order.
Okay.
And if you ignore it, you do so at your peril, because they can go back into court, tell the judge it's not being complied with, and the judge can then make, quite onerous further orders, up to and including imprisonment for breach of a court order. So yes is the short answer to that question. No other questions? Well, thank you again for your time. Thank you.